Thank you, Sean and Sarada from Perth Machine Learning Group for organising and putting all the work in to get us all here tonight. Thank you to Tankstream Labs for hosting us. Thank you everyone for coming. There's been so much space, so much activity in this space that my topic has actually changed from what Sean mentioned just a second ago, and that's to keep up with the recent development. But let's come to that in a second. Can I just do one housekeeping thing before we get going? I know SJ's here, but if there are any other legal practitioners in the room, I'm not sure if there are or not, I have a sign-up form for you here if you'd like a CPD point. I've applied to this only makes sense if it applies to you, so please forgive me otherwise. I've applied to the board for approval for CPD, a point for tonight. It's still being processed, but if you give me your details, we'll try to get it through in the end. And that's where it sits at the moment. That may only apply to me and SJ, I don't know. But for anyone else, if it does apply to you, great. So that's out of the way. Quick introduction for me. My name's David Wilson. I run a small solo legal practice which I call Stratocumulus Legal. Maybe I've got my head in the clouds, maybe big sky thinking, I don't know, whatever you think it is. But I have a career history working in intellectual property law. I've always been interested in how technology is several paces ahead of where the law is at, and it's no different, and particularly IP law is somewhere where that happens. And we'll be seeing tonight a really, some would say landmark, some would say provocative new decision in the last couple of weeks, which meant that I had to update my presentation topic. So I was scheduled to present tonight back in July, but we had our little short snap lockdown in the first week of July, so I got adjourned until tonight, which is probably actually a good thing in the sense that this new development has happened since. So that's why I'm not only talking about can a robot infringe intellectual property. I'm going to try to get up to that if I have enough time, but I really want to talk about robot as inventor. So that's what's happened in the last month or so. First of all, though, I think it's important to acknowledge that we meet on the land of the Whadjuk people of the Noongar Nation, so pay respects to elders past, present and emerging. And on that, before we get into tonight's topic, there's something really cool happening in that space too, which I thought I'd like to share with you. It's nothing to do with machine learning, or it might be in time, I don't know. But I want to talk about inauthentic artwork and how that's become a touchstone potentially for something even bigger. So you might have heard back in the days when we had international tourists visiting Australia, remember that? But back in those days, it was a real problem, people buying inauthentic artwork. Maybe the tourists themselves were unsuspecting, maybe they didn't care, I don't know. But it got to a parliamentary level of concern. And a House of Representatives Standing Committee on Indigenous Affairs put out a report on, it was titled the Impact of Inauthentic Art and Craft in the Style of First Nations People. And that quote there, I think, summarises the problem. It says that First Nations artists in their communities feel that their culture is being stolen through the supply of these imitation products. There were a couple of private members' bills trying to address this problem through proposals to change consumer protection law. So don't sell inauthentic art if and represent that it's real. But they got knocked back, or they didn't proceed through the Parliament, on the basis that this report actually made a recommendation, which was, among others, there were a few other recommendations, but the key recommendation for my interest was to have a consultation process to develop standalone legislation to protect Indigenous cultural intellectual property. And the government accepted the recommendation. So the consultation process has started. A report's due in mid-2022. I've got no idea how broad or how narrow this might be, but depending on where it gets to, we might see, for the IP lawyers, a new type of intellectual property emerging. And I reckon that's pretty cool. So I thought I'd share that with you tonight. I think sometimes acknowledgements of country can be, pardon the pun, it's deliberate, but can be a bit robotic in we acknowledge country, and I think it's important to do, but I thought I had something extra to add tonight, so I thought that was just worth throwing in before we get on to tonight's topic. It's really interesting. Some of our Pacific Island neighbour countries have gone down this pathway already. I think Vanuatu already has a legislation in place for the protection of traditional knowledge and culture. And the question is, how broad or narrowly would we go? The big problem in the intellectual property space is you can't use copyright to protect a style of artwork. It only protects individual art pieces. So if the style of an artwork of a certain group of people is whatever it is, if you then imitate that art piece, then what rights have you infringed? Ethically and morally, you might have done something that was a bit upsetting or at least culturally insensitive, but the law's not going to have anything to say about it. So potentially this could change that. I don't know how long this will take. It could take years. We might never get there, but I just thought it was worth mentioning, so there we go. Sorry, that slide is just a break, but you've probably seen down here, I'll hold this guy up the camera. This is my little mascot. I brought him with me in February, so I thought he'd make a reappearance. But this was, that's my 6-year-old son in the photo there. That was just a bit of a project. I thought if you guys make robots and machine learning stuff, I thought I'd better have an attempt myself, that was all. So back in February, I gave a presentation to this forum, and the topic of my talk back then was, does anybody own intellectual property rights in a robot's creations? And if you were here, you might remember we talked a lot about copyright, and the conclusion was that if a robot creates anything that would in a normal world be a copyright work, then if there's no human author, at least in Australia, if there's no human author, then there's no copyright going to subsist in the output of that. And that affects things like computer programs and text and artwork and music and all sorts of things. And we talked about patents as well. And my conclusion back in February was, well, see, I got this wrong. I reported that a human inventor was also required for the purpose of an invention. And this was the last slide in my deck from February, and I thought this was the great big conclusion. The word intellectual gives a very big clue about what IP law protects, but maybe that's not true anymore, especially since the end of July, where a brand new federal court case came up with the quote is, an artificial intelligence system can be an inventor for the purposes of the Patents Act. The reason I've put maybe with a little asterisk there is an appeal was filed against this last Friday. So we'll talk, and this is the key point of my presentation tonight. We'll go through it and what it all means. As a refresher though, I just thought it's worth going through different types of IP and what they do. This is just to give us a bit of a back to basics, to just put tonight's context in some context, because there's no single thing as intellectual property. It's a word that is commonly used, and mostly I think most people mean the same thing, but around the edges people have different ideas of what it might be. But this is sort of the lawyer's overview of different types of IP, the different features and benefits that they have, and the pros and cons. Tonight we're going to be talking a lot about patents, and a bit later maybe about copyright if I get up to it. But I just thought I'd run through it very quickly just to put everything in place so that you can keep this in the back of your mind as we go through. Patents protect inventions, a method of doing something or an actual inventive object. And that's what we're going to talk about tonight. Copyright protects the expression of an idea or a concept in material form, to oversimplify. It could be music, it could be a novel, it could be artwork, it could be a computer program, it could be a number of different things. A design, when it's used in the IP sense, it's a registered regime for the protecting the shape or an appearance of a manufactured product. I'm not going to talk about that at all tonight, but just throw that in there. Trademarks, you'll be much more familiar with as consumers. Branding, logos, slogans, it's used to indicate the trade source or origin of a good or service. And again, I'm not going to be talking about that tonight. And confidential information is often lumped in with IP. I'd say from a strict legal point of view, it's not a form of property, therefore it's not a form of IP at all, but let's just lump it in. Trade secrets, know-how. It's the confidentiality that's imposed over certain information. We might include that a little bit as we go through tonight, but mainly I want to talk about patents. Now, this was the provocative headline. This is not a quote from the Bible. It's not a quote from some religious text. It's a quote from Justice Beach, a single judge of the Federal Court of Australia in a case called Thaler and the Commissioner of Patents, which was handed down, I think, on the 30th or the 31st of July. We are both created and create. Why cannot our own creations also create? I don't think I've ever come across such a philosophical, existential quote from a single judge of the Federal Court before. So this has got all the IP lawyers, you know, it's got all our heads sticking over. It's got us racing. It's all exciting. Let's talk about Dabis, because this case is all about Dabis. Sorry, you'll see that the name of the case is Thaler. So Dr. Stephen Thaler owns and operates the computer on which Dabis runs. He owns, apparently, the copyright in the source code that runs Dabis. Dabis is the, you lot probably understand what this means much better than I do. It's the device for the autonomous bootstrapping of unified sentience. That's what Dabis stands for. Dr. Thaler, importantly, claims not to be the inventor of the things that Dabis creates. So that's why we're here tonight. So as that little image indicates, it's an artificial neural network. Now, I'm a lawyer. I can't explain what this means. Happily, I think, for everybody, Justice Beach in the case declined to define what artificial intelligence is or isn't. I think that's probably helpful because us lawyers would probably stuff that up. But Dabis itself is, it's more than just an automation or a brute force computational tool, quote unquote. It's an artificial neural network. And I can only quote you from the judgment because my understanding of this stuff is light years behind you as my audience. But let me read out a few things just to give you a handle on what Dabis is. Dabis was trained by a combination of supervised and unsupervised learning. Initially, training was human-assisted via ongoing presentation of fundamental concepts, and on it went. The system accumulated knowledge as the individual networks connected themselves at first into binary and ternary combinations of concepts and then into longer chains of concepts. Then the system was allowed to free run. This was the unsupervised generative learning process, or the learning phase. And once in this unsupervised phase, random disturbances promoted the formation of alternative chaining topologies, which represented different concepts. And those topologies, which differed from those previously observed by the system, were identified by the system as novel. And when those novel topologies incorporated networks that were also identified as significant because they incorporated certain predetermined individual networks, being so-called hot buttons, they were the hot topics. And so that's the process by which this system was not just automation or some brute force computational tool. This thing actually went ahead and could, you know, think by itself. Now, it's not sentient. I mean, I've put who is Dabis in the top there. I'm not suggesting we've quite got to that phase. But I suspect it's the type of device that not many of us have on our desks at home. Have any of you got anything as powerful as this? Maybe you do. I'm sorry. I'm a humble lawyer and don't understand. I understand the legal concepts here, but the technology itself, I haven't quite got my head around.
From that description that you gave,
and I was really paraphrasing John, so it's in the brevity of time I've got. So yeah.
It doesn't sound like something that's not a mechanism, I suppose.
Hang on a second, because what I'm going to show you next is this is the actual patent application based on the claimed invention. Now, I know you can't read that; it's a bit small, but that's sort of just a screenshot of the patent filing sheet. The title of the patent application is "A Food Container and Devices and Methods for Attracting Enhanced Attention." Now, I'm not quite sure the reason why, but we've doubled two different things in one patent application. One of them is a a container with a fractal profile which provides a series of fractal elements on the interior and exterior surfaces, pits and bulges so that they can all stack together. So that's one half of it. The other half is a device for attracting enhanced attention, which is an input signal of a Lacuna pulse train having characteristics of a pulse frequency of around 4 Hertz and a pulse train fractal dimension of approximately 1/2, and a controllable light source configured to be pulsating, operated by the input signal. I don't understand how those two things relate to each other, but Dabus does.
I used to be a patent examiner, and now I do machine learning. So you'd think I would understand some of those claims.
Well, that's not the claims. That's just the abstract.
They were written like patent claims, and they weren't using the jargon of machine learning. They were using kind of the jargon of patent claims, I think, to describe. Yeah, it's almost like he was just making up. He was using patent words to make up. Yeah.
Yeah, look,
I think it's GPT. It's actually.
let me tell you a bit about this project, and then perhaps you'll get an idea of what's going on here. The Dabus project is. I should go back to where did I have my notes about Dr. Thaler. When you get time, go and have a look at the website called artificialinventor.com, and that tells you a bit about the project. There's actually almost an activism project involved in this. So Dr. Thaler is he owns a computer and so on. This patent application has been filed using the International PCT, the Patent Cooperation Treaty filing system, and therefore it's been, through that international centralised filing system, it's been popping up in different countries around the world based on the same application. And that's that's completely normal for patents. So I'm just talking about the Australian angle of it, but this patent has also, in the same form, been filed in the UK, the US, European countries, South Africa, and no doubt many others as well, but I can tell you where it's up to in some of those other places as we go on.
I guess one interesting point might be like patents don't have to be valid. Like when I was an examiner, our favourite one was a method of a robot travelling back in time to make an encyclopedia of all of history, and that was approved. And a device for fusion as well was approved. So like they don't have to be valid.
My favourite one I've ever seen was an American one, nothing to do with machine learning, but it was some sort of a vest or a harness that these tubes that you could wear over your body that a gerbil or a little rodent could run through, and someone had claimed patent rights on that. And I don't know if it was granted or not, but that was. gets to go for a walk with his owner, running around the tubes, around the owner's vest. So you can get all weird and wonderful stuff. That's right. But the important thing I think to note about this particular application is, at this stage, it's just that. It's an application. So there's been a bit of commentary on this case saying, oh, it's amazing, robots can invent, and another myth that is coming up, robots are going to own patents and it's all going to run away from us and this is all a bit sensational. The thing to remember at this stage is this is nothing more than an application, which comes to this slide. What is the legal issue? It's been filed, and that's as far as it's got so far. The application, if you can see, just down here, the inventor has been named as Dabus. The invention was autonomously generated by an artificial intelligence. Now, traditionally, you put a human's name in there, and that's why this case has got everybody's attention. The applicant, if it gets through, the owner will be Dr. Thaler, not the AI system itself. So just dispel that myth straight away.
Could AI sue later?
Well, it's not a legal person, so no, it can't. So that's something that's, for lawyers that's obvious, but for the sake of everyone, that's actually mentioned in the judgment. The computer can't own anything. So
Business. If
yeah, well, that's.
employee of a business is inventing something, the name of the patent owner is the business.
Let's talk about ownership when I get up to it, but yeah, I wonder whether there's some Lenny loopholes around that, but they haven't been tested, so I don't know. But let's get up to ownership in due course. But the key thing at the moment is it's been filed. the application names an AI system as the inventor. The owner is Dr. Thaler. And all that's happened so far is when you file a patent, they check, it's called a formalities check. They check the, you'll know, but they check the details to make sure that it's in a form that can proceed to be examined, to see whether all the other substantive requirements can be met. And because the inventor was named as an AI system, the patent examiner looked at it and said, well, hang on a minute, you can't do that. And after a Patent Office hearing, which I mentioned, and a ruling which I mentioned at my talk in February, in fact, I think that was about a week before my talk in February, and now this is about 3 or 4 weeks before my talk now. So I've timed these just right. But it was rejected on the basis that the inventor must be a human, couldn't proceed. So the Commission of Patents decision, or the Deputy Commission of Patents decision, is that at the bottom, if anyone wants to go and look at it. But essentially it said, the Patents Act requires the inventor to be a human. Dr. Thaler appealed that to the federal court, and that's how we can now get this outcome of Justice Beach declaring that an artificial intelligence can be the inventor, or can be an inventor for the purpose of the Patents Act. And His Honour had, broadly speaking, 6 reasons, so I thought we should just see if we can go through them. Because I think you'll find some of this interesting. I mean, a bit of this is sort of legal waffle and legal speak as we go through, but the reasoning is kind of interesting. So the first couple of points, they overlap, so I'll just put them on the same slide. But His Honour said that there was nothing in the Patents Act. Now remember, the Patents Act was passed by Parliament in 1990, which means it would have been drafted in the late 1980s, I assume, before it actually got passed. So think about the state of the technology in that era, in the background of your mind as we go through this. But His Honour said, well, there's nothing in the Patents Act to refute the concept of an artificial intelligence being an inventor. At face value, I agree with that. It's probably, on the face of the Act, that's probably right. His Honour also said that there's nothing specific in patent law requiring a human author. And he drew the distinction with copyright law. The copyright law talks about, if you go through trace through all the definitions and everything that's in the Act, it actually says somewhere that an author needs to be a human. You can trace it through. But in this Act, an inventor is not actually defined. An invention is defined. I'll come to that in the next slide. But an inventor is not. Now, whether that's a quirk, whether nobody thought to do it back in 1990, whatever, but that's the situation. So His Honour decided that he'd go through what does an inventor mean from a linguistic or etymological kind of point of view, and particularly given that the Patent Commissioner in the decision below had relied heavily on dictionary definitions of what does the word inventor mean.
If somebody didn't have acquired intelligence, would they be able to create artificial intelligence?
Well,
I mean, how did somebody where did the idea come from?
Indeed. Let me come up to sort of reason 5 or 6 or whatever it is, which I think is sort of a better space to touch on that. But looking at the dictionary, His Honour talked a lot about grammar and agent nouns. Now we know that a noun is a thing. You know that a pronoun is a grammatical piece of grammar for I, you, they, he, she. But an agent noun is something that identifies the thing or the entity or the person or to put it neutrally, the entity that performs an action. So one of the examples that sort of comes to mind that's changed meaning over many years is a computer. Maybe it used to be spelt computer or knowhow, but it was once a person who did computations and now it's a device. Other examples from the judgment were controller, regulator, distributor, dishwasher, all that sort of thing. I looked on Wiktionary.com for a few more examples, and I found some great examples, but I found axe murderer, bootlegger, gossiper, dog napper, and hornswoggler. I didn't know what a hornswoggler was, so I kind of like the definitions in the examples in the judgment a bit better. A hornswoggler is one who hornswoggles. It's to deceive or trick. Don't let them hornswoggle you into buying anything you don't need. So could a hornswoggler be a human, or could it evolve over time into being a device? I don't know. But his honours quote was, "Dictionaries are by their nature developed from historical usage. Accordingly, there would be no call for a definition directed to something that invents until that becomes possible." So that was his reasoning there. I guess that's right. When you do compile a dictionary, you're looking at previous examples of the word and how it's been used, and when something new happens, you've got to update. His Honour also pointed to the evolving concept of what an invention is. Now, the language of the Patents Act is still archaic. It goes back to the Statute of Monopolies, the very first Patents Act from 1623, and we're still using the same concept, updated as it is, of a manner of manufacture is what we say. So an invention is actually defined in the Act as being any manner of new manufacture that would have fit the old definition in the Statute of Monopolies. But as technology has evolved, the concept of manner of manufacture has also expanded and evolved as well. To give you just a small example, I read a report just this week of a new patent application for. I didn't get my head around it because I only skimmed through it. But just to mention it as a quick example, it was an application for a patent over some blockchain technology, and the application of the blockchain to what was it? I've got it here. Just thought it was interesting.
The term smart contracting.
Yeah, it wasn't a smart contract patent. What was it? So I did print it because I thought it was interesting. Well, I didn't read it properly because I was trying to prepare the rest of this. A method and apparatus for processing transaction requests. But in patent law, in Australian patent law at least, there's been a great topic over recent years about what can be an invention, particularly business schemes and processes, perhaps putting an old-fashioned manual analog process into a digitised form, and merely doing that and using a computer to undertake what used to be a business function or something done by humans is not enough to constitute an invention. So, but this example here was where the Deputy Commissioner decided that, I think it was at least the patent examiner decided that this blockchain technology did qualify for a manner of manufacture. So it's probably an expansion of previous understandings. But coming back to this, sorry, I got a bit waylaid there. I was just trying to give an example of what that meant. But Justice Beach thought that if the concept of a manner of manufacture expands, well, so too can the concept of what an inventor is, and should be treated flexibly. I think this is where your question sort of comes into play a little bit. But there's a section of the Act, you can see it's Section 2 capital A, which means it was inserted later in more recent years, but it sets out what the object of the Patents Act is. And Justice Beach relied on this quite a lot to say that the reality is technology is already being used to invent things, and maybe in some cases, when a human inventor is named instead of the machine, maybe that's not entirely accurate. And the reality is this is already happening. There's patentable results coming out of machine learning already, so this is just a reflection of that. And I think this is the area where he really shows his different approach in thinking compared to the Patent Commissioner's decision below, where the starting point was, well, do you have a human or not as your inventor, and we'll work forward from there, compared to this area here being the starting point. Well, we've got some output that is probably inventive. It would be unfair if that wasn't protected, having regard to the object of the Act. So I thought that was sort of emblematic of the thinking process of the different approaches. And step 6 is, you might know that one of the substantive thresholds for a patent to be granted is that A, it has to be novel, something that's never been done before on a worldwide basis, but it also has to have an inventive step. It's called above the existing technology base. His Honour thought that the focus of the Act is on inventive step, not the actual identity of the owner. And he was thinking, he sets out that, you know, over time, as technology evolves, maybe inventive step is much more likely to be generated by AI than by a human.
There's the issue of intellectual property, where the results of an activity are not made public. And if there's an error in the process, there could be legal liability for it. But so management covers up the real data in the reports to prevent getting the right data to be innovative and creative.
So there's a bit of an interplay between a patent versus your confidential know-how in how to implement it and use that technology. That's certainly true. Under patent law, you're meant to, as another requirement, set out in your patent in your patent scope, your specification, the best method for implementing the invention. That's part of the quid pro quo for getting your monopoly, is to disclose to the public what that is. But I suspect that that gets you so far, and then there'll be still confidential know-how in the background as to.
You've got chaos at the moment.
Yeah. So back to ownership. No one's disputing that a computer or an AI system can't own a patent. That's not part of this case. But this case doesn't decide ownership, because all it did was decide that this application in this form can proceed on to the next step to be assessed. So it didn't have to decide whether Dr. Thaler is the owner or not. We're not up to that. But His Honour still had a bit to say about it, because in the decision below there was quite a discussion about this. One of the reasons why the patent decision said that, well, a human needs to be the inventor, was to go through this section of the Patents Act to say, well, based on who can own a patent, it needs to be a human inventor as a consequence. So, and Justice Beach had his say. I'll show you what it was in a second, but in response to that. So Section 15 is the section of the Patents Act that says who can be an owner of a patent in Australia. Either the inventor, and we've just discussed that a computer can't be the owner itself, so in this case the inventor can't own it. Paragraph C is probably the most apt one, although His Honour thought paragraph B may apply, depending on the circumstances. But let's look at paragraph C. A person who derives title to the invention from the inventor, or a person mentioned in paragraph B. So the patent decision thought that, well, derives title to the invention required some form of transfer of property, and thought that the computer needs to own the property in the first place to be able to assign it to the applicant. And that's how you derive title. His Honour thought that's not right. And it's always good to see a bit of ancient Latin legal terminology get used for artificial intelligence. But the analogy is fructus industrialis, if that's my best pronunciation of this. The concept is if you have an apple tree in your orchard, that tree is attached to the land, but the apples that grow on it are a separate piece of property when you sell them to the supermarket, and so on. So is a patent the fructus industrialis of an AI system inventing, if you happen to own the AI system? That's kind of where the conversation's at the moment, and His Honour thought that deriving title was a broader concept than just an assignment of ownership from one to the other. So His Honour said, a bit more Latin, there's a prima facie basis for saying, face value basis for saying that Dr. Thaler is a person who derives title from the inventor by reason of his possession of DABUS and ownership of copyright in the source code. So he's laid out the roadmap for how this might need to be assessed by the patent examiner when it gets to that next stage, perhaps. Arguably, this is what lawyers call obiter dicta. It's not part of the decision of the case. It's just some comments about some other things, but it's a pretty strong roadmap for where it needs to go next. What does the Australian government think about all this? Just jump down to the bottom of that before I come back up to the top. So, the World Intellectual Property Organisation, which is a UN-level body, is currently having, and it's proceeding at sort of UN pace, it's having a conversation on IP and AI. And it's had about 3 rounds of this conversation to date. And so far, it's framing with all the different people, countries, and private submitters as well, submitting their thoughts on, at the moment, what are the questions that we need to decide? And that's about where it's at. So it's a very slow process. And as part of that process, Australia put in it's a one-pager, it's very short, but Australia, in roughly June last year, Australia's current legislation requires that the inventor has to be a person and the owner of a patent has to be a legal person. And then Justice Beach comes and upsets the apple cart by this new decision. So Friday last week, the Commission of Patents filed the appeal, and IP Australia has made a short statement to the effect that the Commissioner takes the view that the legislation, the current Patents Act, is incompatible with AI as an inventor, but the appeal does not represent a policy position by the Australian government. So I kind of get it. I mean, I think they're saying this legislation does not work in their view, but it's not a statement on what the broader policy position should or should not be, and that's to be developed in due course. International DABUS cases. The UK has had a very similar process to us, but they're a bit ahead of where we're up to. The Patent Office decision was no, you've got to be human. Appealed to the court, and a single judge of the High Court in the UK found that a human inventor is required. An appeal has been heard, and the decision is still pending. But very similar arguments. Now, the UK Act, I went and had a look at it for a comparison. It actually does define inventor in their Act, so it's an important distinction. But the inventor is defined as the actual deviser, there's another agent noun, the actual deviser of the invention. So because it's another agent noun, does it take us any further than where we are here in Australia? I don't know. But there's a quote from the UK case: the term deviser at least implies someone devising something. In short, the natural reading is that the inventor is a person and the invention is a thing. And there was a reference to a previous case back in 2005, which I don't think was the point of the case, but the judge talked about who was the inventor and used the word a natural person, which I don't think was wasn't thinking about this particular point, but has said natural person, so I think that's helped colour things. But I think very similar issues are going through the UK. As far as I understand from looking at the Artificial Inventor website, the position in the US is that an application against the Patent Office rejection has been filed. Now, the really interesting one is South Africa. The reason I sort of put it as a footnote is because the patent has actually been granted in South Africa, but my understanding of their system is not very strong. So for everyone watching me on YouTube afterwards and telling me I get this wrong, I'm sorry, but my understanding is that it doesn't need to be assessed at this stage. And so it would need to be assessed and examined, perhaps if you wanted to sue someone for infringement or whether you wanted to, I don't know, do you know the answer to that question? I take it it's more like a provisional registration until such point as it is examined.
Yeah, I know some systems are like that. I forget which ones.
But it got past a formalities check. So I don't quite know the substance of it, but there's been a patent granted there. The internet will know, and I'm speaking to the internet as well, I think, so we'll find out. My thoughts are that I think this case has real potential to go to the High Court. It's just too important an issue to leave at a single judge decision now that we've had a decision come out this way. I think that even though the WIPO process is going to be quite slow, there are really strong reasons why that process is going to be internationally important. We have international patent treaties where laws in different countries are meant to line up. And I think there's some real strong policy reasons why this, I think, will end up in the Parliament one way or the other, either to reject this case if artificial intelligence is accepted as an inventor, or to clarify something about it as it gets through to future phases. I can't see it just sitting here, but I guess time will tell. I made predictions back in February about this and I was wrong, so we'll see. It's nearly 7. I'm happy to take questions, but question for the audience is, I can go back to my planned topic from July, or I can stop and we can just talk about this. What does the room want to do? I'm conscious of the time, that we can talk about other things as well. I don't mind. I'll leave it to the room to decide what you'd like to talk about.
Me and John had some questions to try and trip you up.
Yeah, well, you might succeed. I might be clumsy enough.
I had one which is, I guess I just wanted to ask you as a lawyer, but there's this interesting case with this GPT-3 is a famous model in the last few years, and they're trained on a huge amount of text. And when you look at how much text they use, there's not enough public domain text, so we're pretty sure they use...
So you do want me to continue with what I was going to talk about, because that's exactly on topic. So maybe, Sarada, I need to come back twice. What I was going to talk about in July before all this happened, and I sort of had started preparing a list, so I sort of put up the back and thought if I get time I'll get up to it. I was going to talk about exactly this, which is, and John, this was the article you sent me a while back, but can using input data into your machine learning infringe a third party's intellectual property? And we now move out of the space of patents, and we now move back into the space of, I think in the main, copyright and confidential information. So let me whiz through this very quickly. I can do it in more detail next time if we don't get through it properly. But you know that. So the first thing to work out is your input data actually copyright work in the first place? Some things will be, some things won't be. And one of the things I talked about back in February was raw data is not a copyright work. Something that's not written by a human is not a copyright work. So if you're not ticking those boxes, you can do what you like with it, subject to confidentiality, which I'll come back to in a minute. But if it is a copyright work and you satisfy yourself of that, then you need to start considering, do you have permission to use it as an input source for your machine learning? The analogy I was going to draw is this. There's been a debate, and I think the debate has now been resolved, but in the copyright world a little while back when digital technology was new, picture yourself going into a bookshop, picking up a book off the shelf and reading it. And you're absorbing the information off the pages, you're having a great time reading the book, and the bookshop doesn't kick you out. So you're quite happily, and then you walk out, you put the book back on the shelf, you walk out the door, you don't pay any money, you've just been standing there reading. There's no copyright issue involved in that at all. It was an existing copy, and all you did was pick it up and read it, put it back on the shelf and walk away. But in the digital world, it doesn't work like that. If I share a photograph with my friends, it necessarily involves making copies of them as I email them around or post them on the net or do whatever I do with it. So the old concept of copyright, there was a great debate about whether, to the extent to which copyright should protect access to a digital work. And that debate got solved by, as I said, a short copyright lesson. So the Copyright Act affords the exclusive right, here it is. If you're the owner of a copyright work, here is the exclusive rights you get. I'm sorry it's very small, I just cut and pasted so you could see what it says. But the key one is you have the, for a literary, dramatic or musical work, you have the right to reproduce that work in a material form. What does that mean? In the olden days, material form was any form, whether visible or not, of storage from which the work could be reproduced. And that excluded loading up a copyright work into the RAM of the read access memory of your device. And then came along, so the reason I've got a DVD on the screen there is I think that was about the technology at the moment, that I think that's what everyone's worried about. And then came along, at the time, the quite controversial US-Australia Free Trade Agreement in 2004. I remember as a baby lawyer looking at all this at the time and all the controversies that came out of it. This is the text of the actual treaty. It says, each party shall provide that that copyright laws protect temporary storages in material form. So we've suddenly had to go back to that definition and update it. So the US Free Trade Implementation Act said we're going to redefine material form so to whether or not the work can be reproduced. Why did they do it? Well, because they wanted to deal with temporary copies. They'd never explained why they wanted to do it, and that was part of the controversy at the time. And they also introduced at the time a whole lot of strict liability offences where if you got caught, I've never in practice heard of these being used, but if you were copying stuff, you could get pinged with infringement notices, sort of like a speeding ticket. I've never heard of them actually being used, but I think at the time it was sort of being called the iPod copyright laws or something like that. It was the sort of the media tone. But I think what they were really concerned about was pirated copies of DVDs and games and stuff. You know, you'd go down to your local black market and you'd buy a DVD that was an infringement, and then you'd come home and you play it on your console. And the very act of loading it was not previously a copyright infringement. The act of making it would have been, but if you're the mere consumer who purchased it, well, you weren't going to get in trouble for that. But now the act of playing it on your device and loading it up into the read access memory of your computer was going to be enough to make you a dirty, rotten copyright infringer as well. And so, because of these changes back in 2004, that's mucked it all up for you guys with your machine learning. That's what I'm getting to. That's the long story short. There might be a whole lot of other defences in the Copyright Act as to the purpose for which you're copying. But, for example, if it's temporary reproductions for the technical use or in the course of communication, which basically was the concession that when you email it to someone, your own computer makes a temporary copy on the way through. But that exemption only applies for an original work in the first place, not for a copy that you've bought at the market or a pirated copy. And Australia doesn't have a general fair dealing exemption like the US does. We only have really strictly defined, a fair use as the US does. We only have fair dealing defences, and the key ones are set out there. So if you're copying a work within the parameters of what that permits, you'll be okay. But my suspicion is that in many cases when you're putting works into your machine learning device, you're probably not doing it for the purpose of parody or satire. You're probably almost certainly not doing it for the purpose of judicial proceedings. You may be doing it for research or study, but it's quite confined. Criticism or review means you're doing it for the purpose of criticising or reviewing another copyright work. So like a book review or a film review, but not something broader. And the use still has to be fair. So wholesale copying is just not going to cop it.
What about recommendation engines, though? Would that fit into criticism and review?
It might.
Yeah.
It might. And just the point I made earlier about confidentiality, if your non-copyright work that you're using, the data you're using, is not enough to be copyright work, but nonetheless it's confidential to somebody, then the basis on which you're permitted to use it will depend on the terms of the confidentiality. So that's a pre-prepared answer to your question. Sorry, over here. There's kind of.
I was living in Asia in the 80s, and Apple, you couldn't copy Apple. That had a system.
They had protections in place.
But they could copy Microsoft, so Microsoft went everywhere and became way bigger than Apple.
Yeah.
Because there was no restriction on copying.
Well, one of the big cases that led to this temporary copy stuff back in 2004 was a case in about 2002, 2003 called, if my memory is right, Sony against Mr. Stevens, and he made a mod chip for your game console, and he could bypass some of those protection measures that were put in place. And at the time, that wasn't a copyright problem at all, because the court just found he wasn't preventing copying, he was only allowing access to the work. Which comes back to that story before. Should it be? Well, we're talking copyright at the moment. Should it be? Look, these are great existential questions for our time. To what extent should a human versus a machine?
We had a presentation here a few months ago where they tracked the food, like, so they looked at the soil, the seed you put in it, the growing of it, the harvest of it, the delivery of it, the eating of it, and the value is tracked for each process. There could be patent, or there could be payments
Yes.
for copying part of that food process.
Yes.
Because it's all been documented. We seem to have
Yeah.
unlimited storage space now, so we can track each person, whatever.
Well, you know the old arguments. It's the argument about public utility and getting the benefit of what's created versus the reward for creating it in the first
No more
place.
competition.
And how do you balance those two things? That's the struggle. I'll leave that to the room to answer in your own way. I think some reward for creativity is required. To what extent? Well, all these exceptions attempt to balance that.
Excuse me.
Hang on, we've got a
Excuse
question
me.
over here. I'll try to come back to you.
I was just wondering if you could make a few comments about, you mentioned before the idea that a corporation is a legal person, but a AI system can't be a person and can't be the inventor, but a corporation can be, the owner, but a corporation can be the owner of a patent? Is that correct?
Yeah, okay. Sorry, I hope I didn't send the message that I was selling some conspiracy theory about corporations and inventing things. I'm certainly not. In law, a corporation is a type of legal person. A corporation can own property, including intellectual property. And the way that commonly comes about already is that if somebody is employed to invent, then generally speaking, as part of your employment, then your employer will own the intellectual property you create within the scope of your employment. It's pretty standard and straightforward. If you're not employed to invent, but you invent something anyway, well, your employer probably won't get it unless your employment contract says that they do. So there's a lot of variables in that. But all I was getting to before in that earlier comment was we haven't His Honour was quite clear that in the Thaler judgment, that the computer can't own anything, obviously, but a corporation, being a legal person or a natural person, whichever way it goes, is the only thing that could be an owner of the patent. And you've got to work out on what basis that the relationship between the inventor and the owner comes about. I was just wondering at some point whether somebody's going to try it on to say that, well, my robot is owned by my corporation, and we get to the point where the intelligence is developed to the point where the AI files the application all by itself, and so on, and it loses human oversight. I don't think it's going to be allowed to get to that point. One of the points that His Honour really made when he's talking about the object of the Act being to foster development and reflect innovative technologies and so on, was he said, well, there's he used some good language. He said there's a concern that's been thrown up about this, and he said, because I like the language he used, it was colourful. The spectre has been raised that if one permits of computer-generated inventions and computer-generated patent applications, that the patent system will reach a breaking point. Many more novel inventions are likely to be created because algorithms generate more randomness and variability. And how will the volume be processed? Will such a volume have a chilling effect on innovation and others? There are a number of ways to dispose of these phantoms. His Honour's word, not mine. One requires a legal person to make a patent application. So he suggests, a person will have ultimate control over any computer-generated application. So he's saying there's always got to be human oversight as to what goes into the patent filing system. A computer cannot be the applicant, which we've talked about. Further, only a legal person can be granted a patent, so only a person will have title and control over a patented invention. And at this stage, only a human can assess the patent application as well. So there's oversight at that point as well.
Okay. Maybe they could invent an AI system that assesses patents.
Maybe. Sorry, let me just pop over here and then we'll go up the back.
Sorry, I think my voice is loud enough. So if the doctor set the AI to create something,
Sorry.
and then counting AI as the inventor, when it comes to the case of autonomous weapons, this thing can be weaponized without anyone being responsible for it. One individual can set the AI to go and kill someone, and then the AI is going to be the murderer, just same as the inventor.
It's a really different point to patents, but you are right that it's a really important issue as to artificial intelligence and military systems, and what is it capable of, what ethical judgment does it have when activating and using itself, who programs it, program it to what. I agree, there's some really serious issues there that need to be thought about, but it's a bit different to tonight's topic. Yeah?
Yeah, I have a much more simple question than that.
You might stumble me up anyway, you never know.
Just, I wanted, in practical, real terms, the Thaler judgment.
Yes.
What was actually the consequence of that decision? So did he put that forward because there were other patents being put forward by human inventors and he was trying to circumvent that, or what's the whole basis of this?
In a sense, it's a test to see how different
So he was
different
just
patent
testing
systems.
the patent law.
It's a test to see how different patent systems around the world cope with nominating an AI system as the inventor.
Oh, so there's no
And they're seeing what happens. I mean, they claim there's a genuine invention there. The invention hasn't been assessed yet, so I can't tell you whether it's meritorious or otherwise, but the claim is that it is, so at face value I'll accept it for tonight's purposes. As I said before, it's been filed, and that's as far as it's got before it's reached this hurdle.
Yeah.
It's got over the first speed bump subject to the appeal, and now it has to be assessed on the merits as to whether the patent is eligible or not, whether it's novel, whether it has inventive step. The ownership question, you know, we could go up and down the court system multiple times on this one, I suspect. I don't know.
I was just intrigued by what's the real commercial backstory.
Well, the backstory is that Dr. Thaler and a team around him are running what's called the Artificial Inventor Project. And they've filed this application centrally. It's gone into the patent systems of a number of different countries, and they're seeing what's happening. I don't know who's funding it, because running court cases is not cheap. But that's what's happening. Up the back.
Yeah. So you touch on an interesting thing on what constitutes a copyright infringement, which is data versus a creative work.
Yeah.
So my question is, there's been a lot more AI in terms of playing games, and for example, like Go or even online games and things like that. So from my understanding, the way we play games is also a way we express how we express things in the game. So if an AI plays against human and learn from how the human does its thing, does that constitute copyright infringement?
No.
No?
No, because playing a game is not expressing an idea in material form. So if you wrote down, let me give you a different example, which was, I distinctly remember from my copyright law classes when I was a uni student, but it's a good example. Let's say you've got a recipe for chocolate cake, and somebody has written down the recipe. You need your eggs, your flour, your sugar, milk, butter, mix it all together, blend it, make it smooth, put it in the oven, etc., etc. Making the cake is not an infringement of the copyright. You're just following the instructions. But photocopying the recipe and giving it to somebody else would be a copyright issue, because you've actually copied the material expression. But if someone else came up with a different recipe for a different chocolate cake, even if it tastes just as yummy and just as good, that's a different recipe, and someone's come up with that independently, notwithstanding that the underlying idea of a chocolate cake is the same. So copyright protects expression of the actual expression of your ideas or concepts in the way that you do it. It doesn't protect the idea or the concept itself, which I think would be the problem if you're talking about the manner in which you'd play a game, or the process by which you'd move your chess pieces around, or your strategy, or your whatever it is. Does that answer the question? Okay.
All right.
Back to John trying to stumble me up again.
I've got one that I've got a question to stumble you, but actually, here's a genuine question first, and maybe later we can try a curly one. Listening to this example of, of the Thea and the Dabus case, I guess, like, I suppose I feel like this inventive step is probably really critical. Like this claim that a artificial intelligence is independently making an inventive step.
Yeah.
And I don't know, as I think about this, I wonder, well, maybe this inventive step is actually kind of undefined anyway. And, you got to, if I use a CAD program, the CAD program didn't make an inventive step. I just used it as a tool. What if I used a really advanced CAD program?
Yeah.
Your description of the pattern talked about combining different concepts into new and novel ways. Well, if I use a interface to some kind of graph knowledge-based system like a wiki or a Confluence wiki or something, and I've got a fancy interface that lets me, travel, and the interface perhaps suggests new connections between topics that aren't necessarily, directly, but could be inferred.
Yeah.
And then I look at those connections and then I go, oh, that looks interesting. That's a new idea. Maybe I've just used a tool to take an inventive step on a pathway, right? Would you claim that tool is really done the inventive step? So it's sort of like...
Well, there's a couple of things to unpack here. So the first thing is that, remember, the Dabus application is, at this stage, hasn't been assessed. So when it comes to looking at it for the substance of, is there an inventive step that's going to pass muster, hasn't been assessed. So it may not get there. I don't know. It might not. So that's the first point. But I think the question about how do you assess inventive step in the context of AI inventions is a really, really good one. I'll put a little caveat on my comment. I'm not a patent attorney, so I've got much more experience on the legal side of these things. I don't have any experience prosecuting patent applications. It's not what I've done as a lawyer. But inventive step is measured by assessing the existing technology base as measured by the somebody who's already familiar with that particular technology or that particular type of thing, whatever your patent falls within the scope of. So I did read online a comment on an article about Dabus raising exactly this point, and I think it was a really, really good one. And I think it was made by somebody far more knowledgeable than me. So I think that you've raised it as well. It says a lot. But how do you assess the jump in inventiveness when the AI system has only been able to go back and reference pre-existing materials and identify gaps? It's a really good question. I don't have an answer for you, but maybe that's going to be a stumbling block for AI inventions as we go through. How do you show that you've got that spark of inventiveness in this? I don't know. This application hasn't got there yet. So.
Second last question.
Okay.
So just for fun, I think it's just to hear your insight into it, because it's just following on the trail of that commercial idea, because it takes money to actually file a patent and all of that.
Yeah.
So, let's say there is economic benefit and there is money, because money changes people's minds and money needs to flow. So who gets the money? So if let's say the patent actually does file that, an AI can be the owner of a trademark or a patent or things like that. What would the negative consequences be between, having the owner being a legal person or versus being an actual owner? Because I'm busy thinking there's liability when somebody gets injured.
No one's saying the AI or the computer is going to own anything. But the question is does the right exist by virtue of it being created by the AI system? That's the distinction that's really important here. Mm-hmm. Does that? So I just want to follow through with what your question is from that.
Couldn't there possibly be negative consequences then to
to that of some sort?
Negative consequences to artificial intelligence creating property that can be owned by someone else.
Well, by AI, because then at the end of the day...
Possibly. I mean, I think this is the big policy decision we have to have. And when I sort of said back here, where am I? When I said back here that it's a policy issue, I think that's exactly what we need to talk about. I think a single judge decision of a court, His Honour has put an enormous amount of thought and effort into this judgment, there's no doubt, and addressed a lot of policy issues in his reasoning. But I suspect that a single judge is not going to satisfy everybody's question process as to where we should be. Is it? I mean, the IP system was established and has developed on the basis that it rewards, among other things, but one reason why is that it rewards people's creativity and innovation, and individuals get the benefit of that. So if we're going to move away from that, that's a really big existential question that I think needs to be talked about at a much bigger level than just a single court case. I don't have an answer for your question. I suspect there are positives and negatives to all of this, but it needs to be worked through. That's what I feel.
I don't.
Last
So
question. Okay.
I was really intrigued by this analogy that you had about intellectual property and then the agricultural reference, the
yes.
apple orchard and the apples. And I do remember in your first talk in February, you talked about a very specific type of intellectual property for biological or agricultural or genetic kind of products and intellectual property. So
Did I?
Yeah, you did. You said it was a very arcane type of intellectual property. So I guess my question is, with the biological analogy, is it possible to have a genetic sequence or hybrid or some kind of mutation for which you actually ascribe the inventor or whatever the analogy is for an inventor in this type of intellectual property to the life form or the genetic basis for the new intellectual property?
Well,
if you get what I mean.
Yeah, okay. I'm trying to just work through that. There is maybe this is what I mentioned. I can't remember exactly what I said on that topic now in February, but there is a type of intellectual property, I didn't mention it tonight, called plant breeders' rights.
Yep, that was one.
I've never dealt with it in my career. I know there's people who do, but I've just never touched on it, so I don't have a lot of experience with it. But it's the area of botany, right? So if you come up with a new plant species, you may be able to get an IP right over it, and therefore have a monopoly in the propagation of that type of plant. And you often see it if you go into the plant section at the nursery, you'll see possibly on the little tag of each plant in the pot, it might even claim those plant breeder rights there. So this has been developed as this subspecies of the daffodil is the blue daffodil or whatever it is that someone's come up with is a monopoly, and I own IP rights in that because I developed it and propagated it. So maybe that's what you're getting to. That's a type of IP.
So if there's like some kind of
IP right,
wilderness plantation for something, I leave it alone for 30 years and I come back and I discover a wonder drug that's occurred as a result of a biological process.
Well, there's two things. The plant propagation right I was talking about, I've never worked with it, so I don't know how you get to be the owner of that, whether you need to be human or not. I suspect the common thinking is you need to be human, but I don't know the answer because I haven't looked at it. It's a bit obscure for my line of work. But back to, I left the tree growing for generations in the forest and I came and discovered something. That almost comes back to way back at the beginning. That almost comes back to this topic of traditional knowledge, perhaps, because there's stories of pharmaceutical companies going into the forest and learning the plant properties that the local people have known for generations and generations. And the answer to that is, at least in Australian patent law, and I think the states might be different, but you can't get a patent over a discovery. You can only get a patent over an invention. So the mere fact that we didn't know about it, but it's always been there, you just happen to discover it, that's not enough to get a patent. That's not a matter of manufacture. It's only if you've actually invented something. So if you discover something, the invention might be the application of that new thing that you've discovered. That might be inventive.
But plant breeders' rights is something different, isn't it? You're
Yeah,
basically saying you've got a biological system and you're supervising it as part of the breeding and selection process in a way that's probably not too dissimilar from supervising a machine learning algorithm.
Yeah, the distinction with the algorithm, I mean, we're sort of chopping and changing between different categories of things here. But if you're supervising the algorithm, maybe you're just using it as a tool, which means that it goes back to this, you've got a human inventor after all.
Right.
Perhaps. It's not running so autonomously that the human's out of the picture.
Mr. Two persons still have question. One more.
You might get relegated to after the recording's turned off, John.
So it's coming back to the thing I suggested at the beginning. When you look at something like AlphaFold, which is a network which was developed by DeepMind to solve protein folding. So they've open sourced that, so anybody can now use AlphaFold. But if somebody finds a way of folding a protein from that, and protein folding is part of the process of drug discovery and drug manufacture, and understanding the process of folding is part of the manufacture process. So who owns that? You had a network which has derived the process for folding, derived the outcome protein. Is that owned by the person who has used the software to derive that protein, or is it owned by the originators of the original network, which would be DeepMind?
It could be a mixture of things. I don't know enough about your example to know all the ins and outs of it, but it's possible to have joint inventors where different, in the human world, where different people have both contributed to the outcome and to a single invention. I think, I can't remember the specific legal test off the top of my head, but it's something along the lines of who or which people, if there's more than one, who did the most to bring about the actual invention. And different people might have had different contributions, and their contributions might have had different levels of contribution, but who contributed to that inventive spark that brought about the end result? That's what needs to be analysed.
The implication is it may not be, if you're using their software,
yes.
It may not be, even if this passed and went through and you could have robots invented, are you really the legal owner of that software if you're just using something that's they've created? Are they then the true owner
I think it's
beneficiary of that patent?
I think there's going to be a lot of nuance in all of these examples, and they all need to be taken one by one and analysed on their own facts and on their own merits.
That's the role of the post office to play. Everybody would have an achiever's roadmap, and then if you wanted to evaluate something, all the data would be in the post office, and you can't get conclusions with machine learning.
You mean put your idea in an envelope and stamp it and send it to yourself with a postmark on the outside? That I won. Sean, 15.1b is possibly where you come in. There was some talk about, maybe I'll find it after we finish the presentation. There was some mention in the judgment about sort of this type of scenario where if AI comes up with something, the wrong person then claims to be the owner or the inventor, and then you'd use paragraph 1b as the reason the true owner would use that to come back and claim actual ownership. There's some talk about that in the judgment as to that may be a basis on which you could be the owner of an AI-developed invention. I think I've got one last question from John, and I think
I'll keep it very. I'll try and keep it very short for you.
Have a bit more of an informal chat after that.
Yeah. So just thinking about this setting and just some of the things you've said tonight. So at one point, I think you might have made the claim that if that what is not copyrighted is something that was found on the internet that wasn't produced by a person. So if there's
how would you know? But go on.
But let's say there's something that's not produced by a person, and that's sort of not therefore like copyrightable, and so maybe an AI or something could use it without infringing upon any copyrights. So if an AI produces some output and so some data in a general sense of an AI or some kind of machine logs or whatever produces an output, and that output's therefore not copyrightable. Does that mean that, you know, DABUS, not necessarily for DABUS specifically, but like something that creates an output that's an AI, is therefore, you know, not copyrightable? So someone could copy the works of DABUS and therefore not infringe potentially on a patent.
Well, there's two different things going
like,
on. So copyright and patents protect different things, have different purposes and different rules attached to them. So the DABUS's invention looks like at this stage, subject to an appeal, like it can be protected as a piece of IP. But DABUS's expression of writing down sentences and whatever wouldn't be a copyright work.
Yeah, but maybe so then if DABUS is the
That's the
author
distinction.
of the patent as claimed, so DABUS
but
wrote the...
But they're two different things.
But like, so, yeah, I agree, but there's something weird going on there.
They're two different things. And I know it's easy to conflate these different concepts and ideas and different forms of IP and what they protect. But I think that's the answer.
Yeah.
So as it stands, DABUS's invention would be protected, but DABUS's expression, if there is any, is not a copyright work. All right, I think Sarada's keen. Are we finishing, or do you want to keep going? Or
I think people...
SJ's got a question.
Okay, you're a lawyer, you're special.
No one's ever said that before. Hey, thanks very much for the presentation, David. That was great. I've got a question. If it is held ultimately after the appeal that an AI can be an inventor,
yes,
and if ultimately a patent is granted to Dr. Thaler,
yes,
and Dr. Thaler's not been successful in other important jurisdictions, how will that play out?
So we have a
it's
mismatch. It's a good question.
Yeah, it'll be protected in Australia and the information will be public,
Yep,
but it will not be protected in other places.
yep.
So that means someone could just come, get the Australian patent, go off and commercialise it in these other jurisdictions. Is that right?
I guess so.
So is that the reason why the whole WIPO thing is so important? Because we're so small that,
Yeah,
you know.
so under the previous version of the Patents Act in Australia, the 1952 version, which I've never worked under and didn't study at uni because the 1990 Act was brand new and I was a uni student. But my understanding is that the check for inventive step and novelty was only in Australia at that stage. And it was changed in the 1990 Act to be global, probably for just this reason. And in the example you've just given, if the DABUS patent gets through in Australia and all the appeals are going DABUS's favour, etc., if the patent is granted here, but the UK goes a different way, its appeal turns DABUS down, for example, then the outcome will be, until there's legislative change, the answer will be that, yeah, the patent's protected here but not elsewhere. And therefore, if you buy one of DABUS's fractal containers, you've got to pay for it, but if you 3D print one in the UK, you can probably get away with it. But you couldn't import it into Australia because that would also exploit the patent. So I think that's the answer. So that is exactly why the WIPO process is important. And we have international treaties that are meant to harmonise intellectual property regimes across different countries. By and large, most developed countries are consistent, at least in the substance of all this stuff, and that's why.
Okay, awesome. I think we'll call it there, and we'll take a break to people to socialise. But
yeah, sure. And I'm happy to chat afterwards. So come and talk to me.
Would you like to give a hand for David Wilson?
Thank you. Sorry, I skipped through to the bit I didn't talk about. And there we go. I've QR coded up tonight because they're really cool at the moment. So if you scan that, it just goes to my website. Thank you.